So when you purchase the land, so let's say the builder says, all right, so I want, the total land that you want to purchase costs, let's say $30,000. They want you to pay half the money, 50 to 60% up front, right? Now, they don't have the titles yet, right? They don't have the individual titles. They still got one big title, and I guess they will create the other titles in a process. But meanwhile, that could take a year. And they want you to pay every month on the land that you have. So let's say if you put $15,000 down, they'll break the other $15,000 up into 12-month payments. But you could pay the whole thing in 12 months, and that land may have your name technically on it, but how safe is that where you don't actually have the title?
That's an excellent question. See, the juices are flowing now. True what you said. Once we sit here, it's going to start to happen. Okay. What you mentioned, very important question. All of this has to be spelled out in the contract. Okay? Because the contract, one of the first things that we learned when we were studying in law school about contracts in most countries becomes law between parties. Whatever is stipulated on the contract cannot even be overruled by a court under no circumstance. So whatever you get into contractually, that's going to determine what's going to happen. So suppose it's very common for projects to be working on the title, because it's a process to get, the project approved, and then the permits, and then in the meantime, they want to get to work. So by the time the urbanization authorization comes and they're able to, break off the lots into individual titles, that may take a while. In the meantime, they're selling the properties. The contract should stipulate, okay, that, final payment will be made only when the title is available. The contract should also have, penalty clauses. If you are supposed to turn over that, title and at XO, date, and you miss it by months, then, the seller has to be penalized in some way. The contract has to establish, the conditions to nullify and rescind. So if you have major payments, but for some reason they cannot deliver the title, they have to give you your money back, or they're open to be sued.
Another question.
Sure.
Then the same thing. So the question is, if now when I brought two properties I have, it went to an escrow account from the attorney. So now a lot of buyers and even builders now want you to put the money directly into their account. Now with money putting into their account, you don't have access on your money no more. So at least when an escrow account, the seller doesn't have it, the buyer doesn't have it, but it's sitting there, provided that the seller goes through what he needs to do contractually as well as the buyer. So what do you say when people want to sell you, let's say that plot of land, but the builder says, I want you to put the money in my account and not into an escrow account held by an attorney?
Well, here again, no one is obligated to anything that they don't want to. If that is a condition that's put forth, by the builder, you don't agree with it, he doesn't want to move off of that, find another property. Find someone who is willing to, because we provide our clients with escrow services for that reason. They feel safer that the money is with us. And I can't tell you how many times the buyer is like, okay, it's time to make a payment. I'm like, okay, everything's not finished. So I've extended paying, builders for a bit until every T is crossed and every I is dotted. Sure.
Being a consumer and now a developer and a real estate agent at the same time, I know the angles of all of it. And I've said in this room to many people that we will never, as a company, take money directly. I want to make sure that it goes into an escrow account first, and at our stages of draws, when we're ready to take the next draw, and we're doing it by phase, so let's call it 12 units at once we're building, and we're getting into the next construction draw, we will have a progress draw by way of an appraisal, which will show and distribute proven facts that it's done, both on video or drone, and some independent party that can then report back to legal. So therefore, I can never be accused, or the company we have can never be accused of being offside. Whether that makes legal sense in here.
Well, that's because you're responsible. You have nothing to hide.
Yeah.
But if you have a developer who does not understand that, you're more comfortable with an escrow situation, then you have to shop around. Listen, guys, and there's something that I want to expand on. So you see a unit, you fall in love with it, and you love the project. Now, all of a sudden, the developer starts calling the shots. If you don't pay me by this date, then you lose the unit. We need this paperwork, or we need, they start calling the shots, and because the buyer becomes afraid to lose the unit, they start acquiescing to a whole bunch of nonsense that legally places them, at risk. So I'm never going to handle a case based on how desperate the seller is.
Yeah.
Or how crazy he's making the buyer get. I don't get into that. When it comes to law, there is no such thing as a rush. I don't rush. You have to wait. That unit isn't going anywhere. Sometimes it's not even, constructed yet, and you have all this going on. So you have to be careful. There's plenty of projects, construction. The DR is chock full of, these were only a few examples of constructions that are good buys. So don't allow yourself to get pressured